You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, where I make patents less of a puzzle and more of a process. My name is Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This episode is Can AI Be an Inventor? Guidance from the Patent Office. Today we're diving into a question that not only is timely, but also a little weird. Can artificial intelligence be considered an inventor? Spoiler alert, the answer is still no. AI may be doing some pretty impressive things, but the U.S. Patent and Trademark Office, just like the courts, have made it clear it won't be handing out inventorship credit to AI systems anytime soon. But that's only part of the story. While AI can't be listed as an inventor, it can assist in the inventive process, and that's where things get legally and practically complicated. So AI is everywhere. It's generating music, drafting documents, coding apps, even helping scientists discover new chemical compounds and treatments. Tools like large language models and neural networks are becoming key collaborators in research and development. So naturally the question comes up, if AI helps you come up with something novel, is this invention still patentable? And if so, who gets the credit as the inventor? To help address this, the Patent Office released formal guidance in February 2024 and later reinforced in a broader September 2024 presentation. The message is consistent. Only natural persons can be inventors under U.S. law. This has always been the case, but the new guidance is the Patent Office's way of saying, look, AI isn't going away, so let's talk about how this works when machines are part of the process. Under the updated guidance, an invention developed with AI is still potentially patentable as long as a human being made a significant contribution to the invention. That phrase, significant contribution, comes directly from the Federal Circuit's decision in Panu v. IOLAB, which is now the cornerstone of how inventorship is evaluated also for AI-assisted inventions. So what does that mean in practical terms? Suppose you're a biochemist using an AI tool to suggest new protein sequences. You feed the AI some parameters. If it suggests 5 options and you pick one to test based on your experience and knowledge, if your decision-making added intellectual value, like understanding which option has therapeutic potential, then likely you made a significant contribution. You're the inventor. But if the AI not only suggested the sequence, but also modeled its function and told you exactly what to do, and you just followed its output without really contributing to the inventive step, then you probably didn't contribute enough under the law. That can mean your patent application lacks a valid inventor and is therefore not enforceable. Where this guidance is helpful is in clarifying that AI is, legally speaking, a tool, not a creator. This prevents some companies from listing AI systems as inventors, which would render a patent invalid. It also helps patent practitioners and inventors focus on what does count: human insight, judgment, and conception. But just because the law draws a clear line doesn't mean everything is black and white in practice. Consider a software engineer who uses generative AI to design a new interface. If they accept the AI's output without modification or understanding, it's hard to argue they made a significant contribution. But what if they tweak the one layout detail or interpret AI's proposal in a way that solves a long-standing usability issue? Are they an inventor? According to guidance, it's all about the nature of the contribution, not just how much work was done. These are kind of edge cases that will require careful analysis, often by a claim-by-claim basis. The Patent Office also acknowledges situations where multiple people are involved in the inventive process. One team member may configure the prompt for the AI, another may analyze the results, and a third might craft claims. Who's the inventor? The answer depends on who made a significant contribution to the conception of the claimed invention. And importantly, the guidance says not all inventors need to contribute to every claim, but every claim must include at least one human who did. Another important point is disclosure. While there's currently no requirement to proactively disclose that AI tools were used, unless the USPTO asks under a formal rule. If an examiner suspects that AI did the inventing and no valid human inventor is named, they can challenge the application. That could lead to a rejection or worse, invalidation down the road. So while you're not required to say, hey, we used ChatGPT to brainstorm this, you are required to know whether there was a meaningful inventorship and be able to justify it. To illustrate the issues, the Patent Office has published several examples, including one involving the development of a therapeutic compound and another involving a mechanical component for a remote control car. These examples show how a human's analytical or creative decisions, even when working alongside AI, can make or break the inventorship analysis. You can find those examples on the Patent Office's AI resource page. It's also worth mentioning that this guidance applies to all types of patents, utility, plant, and design, and to all applications, including those filed before the guidance was issued. So if you're sitting on a pending application involving AI, now might be a good time to double check those inventor declarations and make sure everything lines up with the new expectations. One thing this new guidance doesn't do is change the rules about what subject matter is patentable, but it does intersect with those rules in important ways, especially when the invention involves AI methods themselves. A separate subject matter eligibility update in 2024 provides examples of how AI-related claims should be analyzed under Step 2A of the patent eligibility test, focusing on whether the claim improves technology or merely implements abstract ideas. But that's a topic for another episode, some of which I've covered before. So to sum it all up, AI can assist, but it can't invent. If you're using AI in your innovation process, be prepared to explain what you, the human, contributed. That contribution must be meaningful and directed at the conception of the invention. If you didn't add enough, you might not qualify as an inventor, and that could make your patent vulnerable. Thanks for listening to the Patenting for Inventors podcast. If you need help navigating inventorship, drafting claims, or any other questions about intellectual property, such as patents, trademarks, copyrights, or other business matters, give me a call at 424-281-0162. Until next time, Adam Diament, and keep on inventing. Just make sure a human gets credit.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.